This is Debt Free in 30, where every week we take 30 minutes and talk to industry experts about debt, money, and personal finance. Here's your host, Doug Hoyes.
It's the last show of the month, and as we do at the end of most months, it's time for our Frequently Asked Questions show here on Debt Free in 30. Last month on our Frequently Asked Questions show, we only got to 2 questions. This week we'll try to get through a few more. Last month, one of the questions we answered was, what are the chances that my consumer proposal will be accepted? Ted Michalos and I went into a lot of detail on that question, so you can go to the show notes over at hoyes.com and listen to the full answer or read the transcript. It was show number 87. One of the factors Ted mentioned was the comparison to bankruptcy. Your creditors will only accept a proposal if it's at least slightly better for them than a bankruptcy. If they expect to get 10 cents on the dollar in a bankruptcy, but you only offer them 5 cents on the dollar in a consumer proposal, there's not much chance they'd go for that deal. Which leads us to today's first question. What are the differences between a consumer proposal and a bankruptcy? To discuss it, as always, I'm joined by Ted Michalos, my Hoyes Michalos co-founder. So, Ted, let's break it down piece by piece. Consumer proposals, bankruptcy, let's kind of go through piece by piece here. First question, will both of them stop a garnishment?
They definitely will. The protections provided by both are the same under the law. In fact, both proposals and bankruptcies are contained in the Bankruptcy and Insolvency Act of Canada. I don't want anybody to go out and read it, although they're welcome to, but it's all part and parcel. So any protection that you have in a bankruptcy, you have the exact same protection in a proposal, which is a great feature because most people don't think that the proposal is protecting them the same way, and that's just not true.
It's exactly the same. So does it matter if the garnishment has already started?
Oh, it certainly does not. So let me explain how a stay of proceedings works. It's just a legal term that means activity against you is stopped. So if someone is threatening a lawsuit, the stay of proceedings means that they won't be able to commence it. If they've started a lawsuit, the stay of proceedings means the process has to stop unless they get permission from the court to continue. If they've already got an order to garnish your wages, well, the stay of proceedings means that has to stop too, because it's not fair for one creditor to be able to take money off your paycheck when you're trying to deal with all of your creditors.
So if I'm trying to decide, do I need to do a proposal, do I need to do a bankruptcy, or can I just deal with it on my own, this stay of proceedings thing you're talking about is kind of a decision maker, really.
I mean, it's probably the most powerful tool in the toolbox for dealing with people that have got debt problems. If you're afraid that somebody's taking collection action against you, they're suing you, they're going to take money off your paycheck, well, a bankruptcy or a proposal will put a stop to that. There isn't any other procedure out there that'll do that except for paying off a fellow in full. And if you could do that, they probably wouldn't be collecting from you.
So if I have a garnishment against me, why can't I just phone up the guy who's got it, the credit card company, the bank loan, and say, hey, I want to make a deal, can you stop it? Won't that work?
Well, you have the right to do that, and depending on the deal you're offering, they might accept it, but frankly, you didn't pay them in the first place. They had to go to the trouble of a collection agency. They had to go to the trouble of a lawsuit to get the money from you. They're not generally receptive to believing that you're just going to come through and pay them, particularly on some kind of payment plan. Now, if you owed Visa $10,000 and you said, I know you guys have sued me, you're garnishing my wages, I'll write you a check for $7,000 tomorrow, I bet they'd take it. Now, if you said to them, stop garnishing my wages, I'll pay you $200 a month for the next 5 years, I bet they won't.
Because they've already got the money coming off your paycheck. They've got no incentive to make any deal at that point.
That's right. And they've already gone to all this trouble.
So when you think it through sequentially then, I get behind on my credit card bill, let's say. What's the first step then that the credit card company is going to do? I get 1 month behind, let's say.
Yeah, so most credit card companies, if you're 1 month behind, they'll put a polite reminder on your next bill. All right, we noticed you didn't pay next month. This month you got to pay double. Call our offices if there's anything we can do to help you. The second month you don't pay, there's often a phone call or a specific collection letter saying, you're past due, we'd like you to contact us so we can deal with this. The third month is when they generally decide to send it to a third party. So it's not their in-house people trying to collect from you anymore. They're going to pay somebody to basically hassle you till you pay, a collection agency.
And why is that?
Well, it's bad for business for a bank to be hassling customers. So let's say, you owe a large bank $5,000 and you're not paying them. They will push you to a certain point because a lot of people just need to be reminded and they will come across and pay. But if you're one of these people that can't afford to pay, The bank doesn't want a reputation as being the person that takes you to court or sues you. They don't want to have the reputation for hassling you, calling you on one of those electronic dialers 10 times a day because you don't answer the phone. It's not good for the bank's business. It's better for them to let somebody else deal with the problem.
So if you've been sent to a collection agency, then obviously the bank is kind of washing their hands of you.
That's right.
Now, we're talking about consumer proposals, bankruptcies. You said that they work fine for garnishments if the court action has already started or if it's already, your wages are already being garnished. What about collection agencies?
Well, same thing. So a collection agency doesn't have any more right to hassle you than the original person that loaned you the money, so the bank or the credit card company. So you file a proposal or a bankruptcy. They don't need the legal stay because that's a technical term, but they are automatically stopped from continuing to bother you. Now, you're into a little bit of a gray area here. The collection agency doesn't know you filed the proposal right away, so they might call you the day you file or the day after. It usually takes a week, maybe 10 days to actually get them to leave you alone. The fastest way to do that is to actually answer the phone after you filed a proposal or bankruptcy saying, look, call my trustee. You're not allowed to do this anymore. They get the law. They'll do it.
Yeah, and when someone files a consumer proposal or a bankruptcy with us, we actually electronically file it with the government, the Office of the Superintendent of Bankruptcy, immediately while the person is sitting in front of us, and we can print out what's called the certificate of appointment that has an actual file number assigned by the government. That's often what the collection agency is asking for.
Well, in addition to that, we make sure that we list both the company you owe the money to and any collection agencies or lawyers that are working for them, so that anybody that's been bothering you or trying to collect on this debt is notified. And as you say, it's what they're looking for is proof that you've actually filed, because they understand the law. Once you filed a proposal or a bankruptcy, they no longer have the right to pursue you. You're not allowed to pay them even if you want to.
So they're not getting any money. There's no point in calling.
It's a waste of cost. Yeah, it's just an expense.
Yeah, they get paid for collecting. If they know they're not going to collect, they're going to stop pretty quickly. So,
That's right.
So when we compare a bankruptcy and a proposal together, they both stop wage garnishments. They're both going to stop collection calls. What about the debts that are included? Do they both include the same kinds of debts?
They do. Again, it's all the same law. Think of it as degrees of separation. So a proposal is designed for people that can afford to repay part of their debt. A bankruptcy is designed for people that cannot afford to repay any part of their debt. But the protections and the debts that they deal with are the same regardless. And they have to be, otherwise you're not comparing apples to apples.
Okay, so what debts are included, what debts are not included?
Well, so it's easier to tell you what's not included than what is included. So if I don't list something now as being not included, then it is. So first and foremost, you can't get out of any kind of support order. So if you owe child support, spousal support, support arrears, bankruptcy proposal is not going to stop those debts.
And so when you say support order, you're talking about something from the court.
That's right, something from family court. You've got an obligation to pay somebody because of a past relationship with you. You can't get out of any debt that was a result of fraud, malfeasance, misrepresentation. So this is kind of a funny one. Somebody actually has to prove that your debt was a result of fraud, malfeasance, or misrepresentation for it to survive a bankruptcy or proposal. So usually what happens is when somebody sues you, they simply get a judgment against you, and the bankruptcy proposal will stop that. Unless the order says that it's a restitution order or you were charged with fraud as a result of this, the debt will still be extinguished. There are also some funny rules regarding student loans. I mean, I call them funny because I don't believe that the way we treat student loans is fair under the law. And you and we gave evidence before the Senate years ago. I still think what they're doing is wrong.
You can go to YouTube and type in Ted Michalos Senate. It was from 2008. We traveled up to Ottawa and actually said to the senators who were reviewing the legislation that we thought the student loan rules were too onerous. What are the rules? Why do student loans not go away in all cases in a bankruptcy or proposal?
So the way the law sits right now, you have to have been out of school for a minimum of 7 years for your student loan debt to automatically be discharged, which means eliminated by a bankruptcy or proposal. There are provisions in the law that you can apply for a hardship allowance after 5 years. It's rarely used because the law never defined what hardship means. So effectively, you go to school, whether or not you graduate or not makes no difference. It's when were you last registered as a student. That's when the clock starts. It's called your end of study date. 7 years from that date, you can include a student loan in a bankruptcy or a proposal.
So the rules are the same. So debts that don't go away in a bankruptcy or proposal, child support, spousal support as assigned by the court, any debt that resulted from, as you called it, fraud or malfeasance. So if I rob a bank, sorry, I'm still going to have to pay that back.
Or you embezzle a bunch of money from your employer, but let's not go there.
Something like that. And then student loans, if I have not been out of school for 7 years, they will not automatically go away in either a bankruptcy or a proposal.
And the other big one is fines and penalties. So if you've got a speeding ticket or a jaywalking ticket or something like that, the bankruptcy court will not remove your obligation to pay another court's fine.
So that won't go away.
Yeah.
What about my car loan, my mortgage, what we call secured creditor? So first of all, what's a secured creditor? Everything you've mentioned was an unsecured creditor. So explain the difference between secured and unsecured.
So a secured creditor is someone who's loaned you money, usually to purchase something, or at the very least, when they loaned you the money, you said, if I don't pay you, you can come and take my house or my car or my trailer or my boat. So secured debts are not dealt with under bankruptcy or proposals unless you surrender the thing that you said they could have. So for example, if you've got a car lease from a big auto manufacturer and that $700 a month payment is one of the things that's really screwing up your finances, you have the right in a proposal or a bankruptcy to surrender the vehicle back, and then the debt will be eliminated. Similarly, you have the right to keep the vehicle as long as you continue to make the payments. And the law actually says if you continue to make the payments, they don't have the right to come and take the car. So they can't say, oh, you filed a proposal, I'm coming to take your car. No. If you say you're going to keep paying and you do keep paying, they have to let you keep it. And that's important. Obviously,
assuming you're up to date on the payments.
Correct.
I mean, if you're 6 months behind on your payments, well, they take your car whether you're in a proposal or not. So,
correct.
So most debts are included. There are a few specific exceptions that aren't, and you've just gone through all those.
So we should actually say very clearly that, so we haven't said anything about government debt so far. Income taxes, that sort of thing. They are included in proposals and bankruptcies. There's a lot of misinformation out there that people seem to think that you file bankruptcy, you still got to pay your old income taxes. It's just not true. 2/3 of the people that file bankruptcy or proposal owe some sort of income tax or HST debt. The law is designed to clean those up, just like your credit cards, your bank loans, your payday loans. Let's not talk about them today.
No, we've covered that many times over the last, and we've got more to come in the next 2 or 3 weeks on some very interesting numbers on payday loans. So we won't mention them again today. The Bankruptcy and Insolvency Act that you mentioned is federal legislation. The Income Tax Act is also federal legislation.
Correct.
That's why it's included. They're two arms of the federal government. They both have to follow the same rules. So, okay, so we've talked about the debts that are included. Why then would I file a proposal instead of a bankruptcy? Well, one of the reasons, I guess, is there's a bunch of stuff I have to do in a bankruptcy that perhaps I wouldn't have to do in a proposal. So what are the things that I, as a bankrupt person, would have to do in a bankruptcy that I wouldn't have to do if I file a consumer proposal?
Well, so I want you to think about bankruptcies as the solution you use when you don't have the ability to repay any of your debt. So it's the thing you can do when nothing else will work. Now, because of that, there are very specific rules during a bankruptcy that you've got to comply with. So first and foremost, bankruptcy isn't free. There's going to be some sort of payment based on your household income and the number of people living in the house. So as an example, a single person making $2,000 a month, bankruptcy is going to be a relatively inexpensive procedure. A single person making $5,000 a month, there are going to be penalties that have to be paid because the creditors are entitled to some of that income. The government's decided that you're making more than a single person needs to live on.
The more you make, the more you got to pay.
That's exactly right. And to facilitate that, in a bankruptcy, you've got to provide proof of your income. So a normal bankruptcy or a first bankruptcy runs for 9 months. For the first 6 or 7 months, you end up submitting pay stubs and reports to your trustee saying, this is how much money I made. Your trustee then does a mathematical calculation to see, all right, are you above or below the government rules for a family of your size? If you're below, the bankruptcy runs for 9 months if you've done everything you're supposed to. If you're above the guidelines, the bankruptcy runs for 21 months and there are additional payments. So that's part of the complication. And those monthly reports are probably the most difficult thing for people to do after actually deciding to file bankruptcy, because every month you've got to keep track of where your money goes.
And we actually think it's a good thing.
Oh, it is, because it teaches you to look at your money. One of the assumptions, and in many cases it's true, people don't actually keep track of where their money goes. So you know how much money you're making, because that's pretty straightforward. You're getting a paycheck every 2 weeks. But you don't keep track of how you spend it. And when you file bankruptcy, you're forced to keep track of, well, so what did I spend at the grocery store? How much gas did I put in the car? Do I realize that I'm stopping at a coffee shop on my way to work every day, and that actually adds up to $100 a month? I mean, these sorts of things. And it's not designed to penalize you. It's designed to let you know where's your money going, so you can decide, you know what? Maybe I don't want to do that anymore. Maybe I'll take my lunch to work. Maybe I'll fill the coffee from the coffee maker instead of stopping, that sort of thing.
So in a bankruptcy, you're going to keep track of both your income and your expenses and send that into your trustee, because that impacts on what you are going to pay each month in the bankruptcy. In a proposal, that rule doesn't exist. What about court? Is there court in a bankruptcy? Is there court in a proposal?
So from a theoretical standpoint, the courts are involved in all of these procedures. From a practical standpoint, it's almost never involved in a proposal. I mean, we do literally thousands of proposals every year, and I can only think of the court being involved in one or two in the 15 years we've been in practice. Actually, it's not even 15 now, it's 17.
Yeah, it's been a long time, since 1999.
Yeah, you didn't have gray hair when we started.
I know, no, that's true, that's true.
Now, the bankruptcy court is much more common. The reason for that is bankruptcy has a set of rules that you have to follow, and if you don't follow the rules, we have to put you in front of a judge to have your bankruptcy completed. Probably 3 out of 4 people, bankruptcy is a straightforward procedure. The only court officer you ever see is the trustee. That fourth case, though, the person doesn't hand in the paperwork, they don't file their taxes, they don't pay what they're supposed to pay, or a creditor thinks that maybe something isn't quite right, and you'll end up in court.
And I think it's the creditor component that's the big difference, because in a consumer proposal, the creditors have their say up front.
That's right. And you're getting, in a consumer proposal, you have the ability to repay part of your debt, and you're offering a deal. It's called a proposal because you're saying, I can afford to do this. And the creditors get to say yes or no or counteroffer. And because of that, they're much less likely to resort to some sort of court action because they've agreed to the deal in the first place.
Yeah, so there's nothing to complain about. Whereas in a bankruptcy, the bankruptcy happens, the creditors get notified about it. They can't stop the bankruptcy from happening. You're already bankrupt by the time they're notified. So the only recourse they have, well, there are some things they can do, but one of the things they can do is say, I object to this bankruptcy ending. I think the bankrupt person should have had to pay more money. They can then go to bankruptcy court to argue their case. That's a pretty unusual thing.
It is. I mean, it's for the most part, the creditors understand that if someone's filed bankruptcy, the reports that the creditor receives shows why, and it's obvious. I mean, the average person that we see, it's something like $60,000 worth of unsecured debt. You can't service that on $30,000 or $40,000 a year. It's just not humanly possible. So at some point, enough becomes enough, and you fall back on the court for relief from that debt.
And that's why in the vast majority of cases, there is no court hearing involved in either procedure. So what about the difference between a bankruptcy and a proposal when it comes to your psychology? Is one better than the other for the person who's listening to us today who's got some debts and they're trying to decide which one to pick?
And the people that we talk to, and it's literally hundreds of people every month, tell us that they feel better about a proposal. That's not a good reason to file one. But when we do the math and we give people the options, they say, you know what? I do have the ability to repay part of my debt, and so I'm going to try to do that. And so there is a bias towards filing a proposal because it's not bankruptcy. You are dealing with your debts to the best that you can. A lot of people view bankruptcy as saying, you know, I can't deal with anything. And so there's a stigma, a social deficit to it. It just
doesn't feel good.
Right.
But it doesn't feel good to go to the dentist and have a cavity filled either. Sometimes that's what you got to do.
Well, and frankly, there are times when it's the correct procedure. I mean, it's to people's credit that they want to repay part of their debt. But from a financial standpoint, it doesn't always make sense. I'm of the opinion that, you know, probably 60-40. So 3 out of every 5 people should be filing a proposal. The other 2 people out of the 5, bankruptcy really does make more sense. And that's a hard conversation to have with people too.
And that's why we sit down with them and go through both the numbers, but also the psychological aspects of it. And there are people who may say, yeah, I understand that I might pay a little bit more in the proposal, but I feel much better about it. I know that the creditors have agreed. We're both on the same page. It's just a business transaction at that point.
Right. And there is value to that. I mean, one of the purposes of all of this, other than just getting your finances sorted out, is for you to have control of your life again. It's for you to feel better about your situation. Well, so if paying part of your debt back in the proposal makes you feel better, then that's an honest, valid reason to do it.
And that's why we call it a fresh start. It's not just for the money, but it's a fresh start in your head as well. So that's an important thing. Excellent. Well, I appreciate that, Ted. We're going to take a quick break and come back with a bit more information on the differences between a consumer proposal and a bankruptcy and how you can decide which one is best for you. That's right after the break. You're listening to Debt Free in 30.
You're listening to Debt Free in 30. Here's your host, Doug Hoyes.
Welcome back. It's time for the 30-second recap of what we discussed today. On today's show, Ted Michalos and I discussed the differences between a consumer proposal and a bankruptcy, and we discussed how you can make the decision to choose one of those options over the other. That's the 30-second recap of what we discussed today. So, how do you decide whether a consumer proposal or a bankruptcy is the best option for you? First, meet with a licensed insolvency trustee. There's no point in meeting with a debt consultant or someone else who doesn't fully understand the process. Start with a licensed insolvency trustee who can help you crunch the numbers. What will a bankruptcy cost? What will you pay in surplus income? And what assets will you lose? That becomes the base case. Then, determine what you can afford to pay each month. If the monthly bankruptcy payment is too much, or if you have assets you don't want to lose, a consumer proposal becomes the obvious option. As Ted mentioned, there's more to it than just the numbers. If you feel better making a deal with the people you owe money to, then a consumer proposal may be the best option for you. That's our show for today. We've got lots of information on the difference between a consumer proposal and a bankruptcy. So to find out more, please go to our website at hoyes.com. That's HOYES.com for full show notes and links to everything we discussed today. Thanks for listening. Until next week, I'm Doug Hoyes. That was Debt Free in 30.
Thanks for listening. That was Debt Free in 30.